Can you talk a little bit about which justices were really trying to thread the needle between what is official capacity and personal capacity, and what you think they were getting at with that in terms of the actions on January 6th?
So, what really concerned me was that both the liberal and the conservative justices seemed to buy into this distinction between official capacity and personal capacity acts. There is some basis for that distinction, but it's really much more in the civil realm. So it is clear that government officials have a certain degree of immunity when it comes to civil liability for official capacity acts. But in my view, that really doesn't carry over to criminal liability. And here we're talking about criminal liability. So they spent a lot of time trying to figure out what things are criminal and what things are civil, and seemed almost at times to accept that there could be immunity for official capacity acts, but just laid stress on the idea that a lot of the acts involved in the January 6th context might not be official capacity, might be personal capacity. Now, however important that distinction might be in the civil arena, I don't think it's an important distinction in the criminal arena, because there can't be any immunity for official capacity crimes. There is no such thing as an official capacity crime. So
You think
instead of
crime is crime, crime is
crime
crime.
is crime. So the president doesn't get a pass for committing crimes and saying, I did it as president. It's different in the civil arena. And so what the court should be saying is this distinction doesn't matter. The president doesn't get to violate the law, period. He doesn't get to contravene federal criminal statutes like the obstruction statute or murder, which might be involved in the SEAL Team 6 example. And so it really doesn't matter. And it doesn't have to go on remand down to the district court, because Tanya Chutkan doesn't have to figure out what's official capacity and what's personal capacity here. All she has to do, and this can already be done at this stage, is say there is no immunity for any criminal acts committed by any president, and now the trial can begin, and a jury can figure out whether or not former President Trump has committed criminal acts. It's very straightforward, it's very simple, and this is really a red herring to try to figure out what acts are personal and what official.